Again, that depends on the nature of the business. But obviously, the most important uh, thing to get right is to hire the right person for the job that you have in mind, which really is not legal advice. It's just kind of being involved in businesses within my law firm and outside of my law firm. That certainly can make or break a business. So to find somebody that's competent and trustworthy and matches your particular business model certainly has an effect on the way your business is going to run. Now, once you get to that point, then you may or may not have employment agreements. It depends on how sophisticated the business is. Florida is an at-will state, so you don't have to terminate someone for cause, but you may have some contractual relationships that spell out exactly why a person can be fired. So even though if it defaults to no cause, you may have a contract that says, well, you have to pay this person, and if you terminate them without cause, then you have some monetary obligation that could be liquidated damages, so they're spelled out in the contract, or just whatever damages the employee can prove. And then, as I stated before, you may be in a business where you may want to have the employee sign a non-compete, and you certainly want to have them do that at the beginning as opposed to midstream. You can do it after they've been working there for a while, but that becomes kind of problematic, or can be problematic. Same with intellectual property agreements, so that they don't disclose to competitors intellectual property that really belongs to your company and not to competing companies or the employee that leaves. And then it's really, really important to have, especially in this day and age, for just a variety of reasons, to have an employee handbook, so that if the employee violates a policy of the company, unless that policy is deemed to be illegal or deemed to be so unconscionable that a judge or a jury would say that's not going to work, even if you had it in writing. But typically that's not the case. So if you have an enforceable term within that policy and you present it to the employee and you make sure that the employee signs saying that they have received it and that they've had the opportunity to have counsel review it, and that they understand it and don't have questions about it, and then you've headed off some problems if they violate that particular policy. Now, if you just sit down with somebody and say, oh, by the way, we have a policy of X, Y, and Z, and nothing's ever put in writing, then it's going to be a he said, she said, or he said, or she said, scenario, and that's going to be much more difficult to prove. So an employee policy handbook is a good thing to have. And sometimes if your business is big enough, you will have, human resource department that handles that, but that certainly needs to be checked over by the attorney if that's the case. And if not, a lot of times the attorneys kind of set up everything for the business, including those as well, and kind of acts as the HR person for the company, even though the attorney doesn't hold that title, and can draft or help draft the employee handbook.